I was home getting ready to go to work. Chris had left with the boys to go to work, and they came knocking at my door, and I opened up and they said that we're here to seal your house and you have a few minutes to leave. And they gave me some paperwork and said that you can go see a judge in about a week and to unseal your home. So of course immediately I called my husband, and they gave me some time to start packing up my stuff, my husband's, my daughter's, the dog, the other boys, and in about a couple hours, they sealed our house.
When I got the paperwork back and kind of the notes and the history, it just seemed like a crazy story that here are these people who were not only having their house threatened with forfeiture, but effectively were kicked out of their home for over a week while they were trying to figure out what was going on, and all because their son had sold $40 worth of drugs.
The person who gave me the paperwork told me that in a week we'd go see the judge, and he can explain our reason why we shouldn't be thrown out of our house to the judge. And he says that this is a process that they do all the time. They do 3-4 of these a week. It's like, it was like absolutely nothing to him. Like he came in like it was just another beautiful day for him, with no remorse, no answers to my questions, nothing.
So all right, well, let's go tell to the judge. So no, you gotta go after a week. So what I'm gonna leave all this the week? On the streets? Where? You know, well, I don't care. Where are you gonna go?
Civil forfeiture is a kind of long-standing historical doctrine in which the state claims, and it may be a locality, it may be the state, it may be the federal government, that real property or cars or other property were used to facilitate criminal activity. So for example, if a car or a boat was used to transport drugs, the government's claim is not only did you violate the drug law by transporting those drugs, and you could be penalized for whatever you might have done there, but that the state has the power then to seize, forfeit that car, boat, or as I'll explain, houses, because the property facilitated the criminal act.
If people are using a home to sell drugs from, that home can be seized, and the goal is to try to deter that crime, to prevent that crime, and also to make it less profitable for people who are violating the law. And so it allows law enforcement to be able to go into a civil court as well as a criminal court, but to go into a civil court where there are different standards, and to file a petition to try to seize the property. And if the courts agree, then that property goes to the law enforcement entity, and they can do with it what they want, such as selling it as auction.
After I bought this house with my own money, with my own work, they tell me to leave and go see a judge. After a week, and when we see a judge, we don't see no judge. We see a bunch of those guys telling us what to do with our lives and with our home. Give us the papers, fill up this application, fill it up this, fill it up that, come back in a month. For what?
So we started a process of monitoring courtroom 478 specifically, and having someone there to both see witness for ourselves what the procedures were going on and how courtroom 478 was being run, as well as interview property owners who were coming through this system. And it really is, it's like a machine. When we did analyze the data, it was thousands and thousands of cases coming in. I think at this point, in about a 6-month period, it's over 4,000 cases.
Their explanation was, this is a process that we do, and it just takes time. And I believe that you probably won't need to see a judge, but this is just the process. They were the words that they used. There was never like any kind of direct, well, we're going to go to a judge and we're going to have a trial, nothing like that. You're never going to have, yeah, I was told I didn't need a lawyer because this probably won't go to the judge. For us to have our house unsealed, that I need to write a letter why I have such an urgency to get back into my home. And then we went over to another courtroom, never seen a judge there. He went in and seen a judge and unsealed our home.
And it was these really unique procedures that were going on in Philadelphia in this, what is now infamous courtroom 478, where prosecutors are running the show, where prosecutors are often, at the time at least, were advising property owners that the process isn't complicated and they don't need an attorney, all sorts of abuses at the procedural kind of level. And that was something that we found unique to Philadelphia.
But they didn't let us know verbally, it was written and I didn't really read it, that our son was not allowed to come back home. So that was another heartache. So then we had another, about a month later, we were to go back to this room 478 again, thinking that things would get cleared up. And again, that didn't happen. And it just continued every month. And at the same time, our son wasn't allowed home. And that made it even worse. The biggest thing was, if your child has a problem, you as a parent need to be there to take care of him. If you send him to a rehab and you think once he gets out and he's not allowed home, how do you take care of somebody who's back out? What if he didn't have somewhere to stay? You're just setting him up for failure.
I had first learned about the situation in Philadelphia because of Isaiah Thompson's great reporting in the city paper. I think it was back in November 2012 or thereabout. And I remember reading these articles about, his article about what was going on, and it was kind of a shock because as bad as the system of civil forfeiture is, it seemed like in Philadelphia it was taken to a whole nother level.
Yeah, so I mean, I was coming at this as a total sort of amateur and not knowing anything about this. And so it struck me, as I think it strikes a lot of people, just sort of incredible on the surface. Okay, wait, how you can have property taken from you and seized via something that sort of seems like a criminal process, only you haven't been charged with a crime or you haven't been convicted of a crime. That just seemed completely incredible to me. And so I wanted to know, how many people was this happening to? How often was this happening? What was being taken? Why was it being taken? How were people finding the system if they were, trying to show up in court and get their property back? What was going on here?
Legally, we've got to target what may be unconstitutional. That's the claim that the federal constitution was violated, and it's mainly a kind of due process claim, that before you can seize someone's home, they're entitled to a hearing. Before you can seize somebody's property, they're entitled to be able to come to court, and in a way that doesn't deter them from making their claims.
But we don't just go and take properties on our own, unchecked by anyone. We have to, like in any civil matter, we have to file a petition with the court. And if a civil judge is satisfied that by a preponderance of the evidence, that home is being used for some sort of criminal enterprise, the judge could allow the government, law enforcement, to seize that property. and then ultimately, possibly, with court approval, to forfeit that property.
So once the government meets a very low standard of civil forfeiture, showing that property is subject to civil forfeiture, the burden shifts to the owner to affirmatively show that they're innocent and they're not guilty. And that really turns a whole presumption of innocence, which is a hallmark of the American justice system, on its head.
The judge could allow the government, law enforcement, to either give that property to a community group or maybe even to sell it at auction, where that money then would go towards the furtherance of law enforcement to prevent more crime or to help people that are addicted to drugs or whatever that county law enforcement agency believes is most appropriate.
What the district attorney's office in Philadelphia has done has made this into a major enterprise. They seize property worth $6 million every year. Not only do they seize that property, but under the forfeiture law, it doesn't go into some general fund in Philadelphia to help, fight drugs or educate people. It's money the district attorney's office and the police department keep. So another claim in the lawsuit, there's a conflict of interest. Their whole unit is now, their forfeiture unit is now subsidized by these forfeitures. So there are a lot of things that have gone wrong here in Philadelphia and around the country.
A ton of great reporting, I think, has really changed public perception around this, in that, people get, I don't think it's hard for people to get that there's something kind of unfair about the idea that you can lose your property, even property as valuable as your home, the shelter, not only your shelter, but the shelter of your family, without being convicted of a crime, without even being charged with a crime. People understand that that's problematic, to say the least, but they didn't know it was happening. And I think all this reporting on civil forfeiture has really brought that to widespread public attention.
They think, oh, he's the evil DA. He's taking some grandma's house. And she did not know. Well, in those situations, if it can be shown, and we do our own due diligence, if we really find that the grandma didn't know, then we're not going to try and take her house. But in the vast majority of those cases, grandma knew that the flat screen TV that, Junior, who's 14, has no legal means of income, but he just got her the, 56-inch Samsung high def that even I, as the DA, can't afford. Something's not right.
I think there are probably situations where the parents know or have some inkling of what might be going on, but most of these cases are not repetitive arrests or searches. Most of these seizures are after the first arrest of the kid. We should all think about when we were kids. We didn't share a whole lot of stuff with our parents, certainly not selling drugs. So I think it's a very mixed bag. But even beyond that, and when you go beyond that question, so let's assume the kid has sold one $10 bag of marijuana, right, which he kept in his room. Parents may have known about it, kid's arrested. Think about the disproportionality, right? I mean, he'll probably get probation or something will happen in that case, first offense. You see somebody's house, $200,000 house as a penalty for that. I mean, that's really disproportionate to what went on.
My son, even to this day, is very, very sad and upset over what he put us through. And the fact that, and also, he didn't even know this existed either, so it's kind of like, a surprise to him too.
And I think just in reviewing the Sourovelis case, the DA's office rightly decided that they were in fact innocent owners, and this case probably should have never been brought, and so they dismissed it against the Sourovelises as well as one of our other named plaintiffs, Doyle Welch. So at this time, there's no longer a state court forfeiture proceeding against the Sourovelis family, but they are still very integral to the federal lawsuit.
I was this torn, I guess, halfway, because I still had the nightmare of the whole incident, but yet my excitement to have my son home was like Christmas. It's amazing.
The ideal system would be to get rid of civil forfeiture, would be to say use criminal forfeiture. If you want to forfeit property, whether it's a house or a car or cash, prove guilt first. Prove a relationship, a nexus between the person who is found guilty and the property, and then forfeit the property as part of the overall penalty. So our fallback position is, if you're going to have it, at least do it in a fair way.
But we need to do a better job, I think, in educating the public as to what civil forfeiture is. We have to do all that we can to ensure due process for people whose homes may be taken. I have no problem with that. I agree. Maybe we should even do a better job to ensure that law enforcement is doing the right thing and that those who could lose their properties are represented in some fashion. Because in many ways this does affect people who may not have assets to hire their own civil attorney.
I guess the number one thing is if you believe in something so strong that you've done nothing wrong, that you need to fight for it. I believe a lot of people, even myself in the beginning, are afraid to deal with the DA or the police or the city because you have that fear that you're going to lose. But if you believe in something that's so wrong that you can make a right, then do it. And I think the young generation need to step up and realize what's going on in their city and the rights that they do have.
The civil forfeiture lawsuit that was filed last year is a class action against the Philadelphia District Attorney's Office and makes three primary claims. First, we allege that the process that has been used in the past, where homes have been subject to forfeiture, were unconstitutional in that these houses were being seized and sealed without any notice to the homeowner and without any provision for a hearing before a judge before the house itself was seized. Second, we alleged that the district attorney had an inherent conflict of interest in these proceedings, since not only were they the party instituting the forfeiture proceedings, but they were the party that was standing to get money as a result of these proceedings. That is, the money that was seized and forfeited in any forfeiture proceedings were being used by the district attorney to enhance its own budget. And third, we alleged that the procedures that were used in all forfeiture proceedings in courtroom 478 in City Hall were unfair and unconstitutional. We have reached an agreement, a settlement with the district attorney on the first claim, which is probably the most important one in the lawsuit, regarding the procedures that can be used when the district attorney attempts to forfeit
a house or a home. As I mentioned in the past, what has happened is that persons who owned houses lost those houses. The houses were actually sealed and seized, and they were removed from those houses without any notice and without any opportunity to be heard before a judge, based simply on the allegations that somebody in that household had sold drugs from the house, even if the homeowners had no knowledge of it. The district attorney has agreed to stop that practice, to give notice to any homeowner as to any forfeiture proceeding, and to give that homeowner a hearing in court before the house can be sealed. That's very important, obviously, to protect the homeowner's due process rights and to assure fair proceedings and to ensure that they are not then coerced into accepting conditions to get back into their house, conditions that were unconstitutional themselves, for example, that certain members of the family could not live in the house in the future. We are also negotiating with the district attorney concerning the procedures in the courtroom 478 to ensure that those procedures are fair and consistent with due process protections. And finally, the conflict of interest claim will go to trial sometime in the future.